Thanks for joining us today for this session sponsored by Shepherd Mullen, entitled Workers' Compensation Update, COVID-19 Rule Changes and More. Our speaker today is Keahn Morris of Shepherd Mullen. Take it away.
Hi there, welcome to the Emerging Labor and Employment webinar. My name is Keahn Morris. I am a partner at the law firm of Shepherd Mullen. My practice is exclusively devoted to labor and employment law. I've been working with CAHF for about 7 or 8 years. And my practice split between litigating labor and employment issues as they relate to health facilities, and then also advising health facilities on compliance with the various labor and employment laws. I represent clients anyone ranging from large hospitals to skilled nursing facilities to ICFs and various kinds of those facilities, as well as other health facilities. We have a ton of labor and employment developments to cover today. We're going to cram it into 50 minutes. So I will be going through this material relatively quick, but feel free to ask questions as we go through this. With that, why don't we just get right into the agenda? There's quite a bit to cover. We're going to touch on all of the various aspects of the extended leaves and benefits that exist in California and also under federal law. I will cover the expanded CFRA law, which will go into effect January 1st. We'll discuss employee testing, some of the employment issues associated with that, and also discuss compensable time and how you want to track that and record that. And then we'll get into some of the safety-related issues associated with COVID, as well as a new law that goes into effect January 1 and modifies the law with respect to notice and reporting of OSHA investigations. And then we'll get into PAGA-related lawsuits and then close with the workers' compensation expansion law change. So with that, let's get into the supplemental paid sick leave laws. The first thing that I wanted to cover is the California supplemental paid sick leave law. This is a new law that just recently went into effect, and it really applies to, or potentially applies to, almost every health facility out there. It can come up in 2 primary ways. One is if you have more than 500 or more employees nationwide. And the other way it can come up is if you have certain employees who are considered healthcare providers under the federal law, the FFCRA, and you opted not to provide the leave under the federal law. And we'll get into some of the nuances of that. So turning to the next slide, with respect to the components of this benefit under the California law, there are 3 reasons for which an employee can take a protected leave under the statute. It's either going to be due to a quarantine or isolation order, a healthcare provider's advice to self-isolate, or if the employee is prohibited from working due to potential transmission of COVID-19. It's important to keep in mind that the DLSC, the agency who is responsible for enforcing this, has instructed that this benefit needs to be available immediately upon the oral or written request, and it cannot be conditioned on obtaining a medical certification. There are situations if there's notice of potential fraud, which could lead to further investigation, but that's the current law with respect to the DLSC's position. Keep in mind with respect to this leave, unlike the federal law and unlike a lot of the local ordinances dealing with supplemental paid sick leave, it is not available to care for another individual. It's simply for an individual's own health reason. So turning to the next slide, let's talk about the amount of leave. Really, it depends on whether an individual is full-time versus part-time, and there's various formulas for coming up with that amount of leave. But if we're dealing with a full-time employee, it's going to be 80 hours, and with respect to part-time employees, whether they work a a regular schedule or a variable schedule, there's a different formula for calculating that. It has to be paid at the highest of either the employee's regular rate of pay based on the last pay period, or the local minimum wage, or the state minimum wage. So in most cases, we're going to be looking to the regular rate of pay. Now, turning to the next slide, dealing with offsets. We do get a lot of questions on whether you can offset it if you previously provided paid sick leave for other reasons, such as COVID-19. And you can, in fact, offset it, but there's a number of different conditions that you need to meet in order to offset it. The first of which is that the leave has to be provided for the same reasons. So again, this couldn't include childcare or care for another person. And then second, the compensation provided by the previous leave would have to be the same or greater. Keep in mind that if you're looking to satisfy this second criteria, an employer can provide retroactive payments for the first leave to satisfy the compensation requirements. Okay, so turning to the next slide, a couple of distinctions from the federal law that I want to point out. There is no exemption if you have a collective bargaining agreement and have already provided paid sick leave related to COVID. There are some very important notice requirements. The first of which is that you need to essentially post a notice informing employees of their rights to take this leave. This is going to go in the same place that you have normal workplace posters, typically in employee break rooms and other areas. And then importantly, you want to update your wage statements to ensure that it includes the amount of available supplemental leave. This last component is very important. In California, there's a number of different requirements in terms of what needs to go into the wage statement. And we're seeing a lot of litigation surrounding this in the class action sphere. And we expect to see additional class action litigation for the failure to note the amount of available supplemental leave on wage statements. It's a seemingly easy fix, but it can lead to a lot of liability. Keep in mind with respect to the state statute, it is effective September 19th of this year. It is set to expire at the end of the year. However, if the federal counterpart, the FFCRA, is extended, then the state law will also be extended. Also keep in mind that non-compliance with the statute obviously can result in litigation, could include civil penalties, and also award of mandatory attorney's fees if an employee is to prevail in that action. So we've covered the state law, and now we need to go back to the federal law, the FFCRA. I briefly want to touch on this because it's possible that you exempted certain employees if you were covered by the federal law, and if so, then you need to comply with the state law potentially. So first off, with respect to the federal law, it does apply to employers with fewer than 500 employees. There are two components of the statute. One is an emergency supplemental paid sick leave, and then the other is an extended emergency family and medical leave. It is, like I mentioned, set to expire at the end of the year, but there's been a lot of discussion about extending that, and we'll likely see some additional legislation in that regard. Turning to the eligibility formula for determining supplemental paid sick leave under this bill, that's the first component. It is available to employees for 6 different reasons, some of which include an employee's own condition, and other reasons which include caring for a family member. It can come up in a number of different ways, including that the employee is subject to a federal, state, or local COVID-19 quarantine or isolation order. It can come up if an employee is advised by a healthcare provider to self-quarantine due to COVID-19. And it can come up if an employee is experiencing symptoms of COVID-19 and is actively seeking a medical diagnosis. The other ways it can come up on the next slide is if an employee is caring for an individual who is subject to a quarantine or self-isolation order, or has been advised by a healthcare provider to self-quarantine due to COVID-19. It can also come up if the employee is caring for a child, if the school or place of care has been closed, or the child care provider is unavailable due to COVID-19 precautions. And then finally, there's a catch-all if an employee is experiencing any other substantially similar conditions that are specified by the Secretary of Health and Human Services. So turning to the next slide, dealing with benefits. Similar to the state law, it addresses full-time and part-time employees. Again, with full-time employees, it's going to be 80 hours, and part-time employees, it's going to be 2 different ways for coming up with that calculation. In terms of the amount of the benefit, it is capped depending on if the use is for an individual or for an individual's family member. It's capped out at $511 a day or slightly over $5,000 if the employee is using it for their own condition. And then it's capped out at 2/3 of the employee's regular rate if it's to care for a family member, and it's going to be capped out at $200 a day or $2,000 total for using that leave. Now, very briefly, a couple miscellaneous points that I wanted to point out on the next slide with respect to this first component, the supplemental paid sick leave. It's important to note that you can't require employees to use other paid leave before accessing the emergency paid leave, but employees can choose to or elect to do so. And this tracks the state law as well. In addition, based on mutual agreement, the benefits may be intermittent if an employee is able to telework part of the time. And that's an important distinction. It's specific to teleworking, which was unclear based on the previous guidance. And then finally, there's no requirement to pay out unused emergency paid leave on separation. It's not like vacation or other benefits, so no need to pay out. Now I'd like to move on to the second component of the federal statute. This is the extended leave under the FFCRA. In terms of eligibility under the extended leave, it is dependent on whether an employee has been employed for at least 30 days and is also unable to work or telework due to the need to care for a minor child because of 2 different reasons. Either the school or place of care has been closed, or the child care provider of such children is unavailable due to a public health emergency. Turning to the benefits under this extended protected leave, it is technically 12 weeks of job protected leave related to COVID-19. You have to break it down though with respect to the first 10 days and then 10 weeks beyond that. The first 10 days is unpaid, but it can overlap with the supplemental paid sick leave that we just covered under the previous slides. And then the 10 weeks of paid leave is going to be at 2/3 of the regular rate of pay not to exceed $200 a day or $10,000 in total. Keep in mind that if you have employees that work are part-time and work regular schedules or have varying hours, there are specific tests for determining how to calculate those hours and the average wage rate. So turning to the next slide with respect to job protection under the federal law, it is similar to the federal law, the FMLA, in that the leave is job protected and an employer must return the employee to the same or equivalent position upon return to work. There is a fairly limited exception for employers with 25 or fewer employees if the employee's job was eliminated due to the pandemic. But in most cases, an employer must still make reasonable efforts to restore employees to an equivalent position if possible. Turning to the next slide, I wanted to flesh out a couple of miscellaneous points with respect to both components, the expanded sick leave and the expanded leave. Please keep in mind that you need to get proper documentation in support of the leaves. This is mandated by federal law. You also need to post a notice of rights in the same area that you would post these types of workplace posters. There are some limited exceptions to the FFCRA obligation, including ones that deal with collective bargaining agreements, as well as small businesses with fewer than 50 employees. And then more importantly for this audience and most of the facilities who are chiming in, there is a limited exception for employers of healthcare providers, which I'll touch on in the next slide. But before I get to that, I did want to point out that under the federal law, with respect to these paid benefits, there is a tax offset. This is different from the state law where there is no tax offset. Keep in mind also, similar to the state law, that noncompliance can lead to litigation, civil penalties, and award of attorney's fees. And since the rollout of the federal law, we are already starting to see litigation in this context, especially as it relates to health facilities. So turning to the next slide with respect to challenges to the FFCRA regulations, the DOL, the Department of Labor, issued a number of regulations in connections with this federal law. However, there were a number of different challenges over the course of the summer. And in August, a federal judge in New York struck down portions of those regulations. It resulted in some revised regulations coming out in September 2020. And with respect to these revised regulations, there are two components that I wanted to flesh out because they're the most significant for this audience. First is there's a revised definition of who a healthcare provider is. And with this regulation, it narrows the situation or the circumstances in which an employee may be considered to be a healthcare provider, and thus whether you can exempt certain individuals from the federal law. Under the revised regulations, the DOL has stated that the narrow definition of a healthcare provider is those individuals who meet the definition of a healthcare provider as set forth in the FMLA, the federal law, and also employees who are employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care, and that, if not provided, would adversely impact patient care. Now, the revised rule does set forth a non-exhaustive list of employees who will continue to be eligible and thus eligible for exclusion under the statute. There's also a number of individuals who are explicitly called out as not being related to healthcare services. Those include those individuals such as IT professionals, building maintenance staff, human resources personnel, cooks, food service workers, record managers, consultants, and billers. The other aspect of the DOL's regulation is there is a new revised language in which employers can no longer require advanced documentation supporting the need for the FFCRA leave. Now, turning to the next slide with respect to local ordinances. We've covered the state law, we've covered the federal law. Now, we briefly need to touch on the local ordinances. There's been a number of different cities throughout California, including major cities like San Francisco, LA, San Jose, among others, who have rolled out various COVID-19 and supplemental paid sick leave requirements over the past few months. Please keep in mind that these local ordinances do in fact overlap with the California law and the federal law, but there are a number of different differences, some of which we don't have time to go into today. But with respect to the state law, I do want to point out that there are a number of different differences associated with the reasons that you can take the protected leave and how these leaves potentially run concurrently. So if you have facilities in jurisdictions with these local ordinances, you want to ensure compliance with the state, federal, and local laws. And then turning to the next slide, you certainly want to, in all jurisdictions, be mindful of your specific policies to ensure compliance with these applicable laws. You want to understand the interplay between the federal law, the state law, and the local laws. And for those of you who have are covered by the federal law, the FFCRA, that opted to exclude certain healthcare providers, You want to ensure that you still meet that revised definition under the DOL's regulations, and you might consider whether you want to provide the benefit or whether there's a need to comply with the state law. So turning to the next topic on today's agenda, that's the expanded CFRA coverage. This is a very important bill that addresses an existing law, the California Family Rights Act. This is a state law that has existed for a number of years. The existing law provides eligible employees with up to 12 work weeks of unpaid leave in a 12-month period. And the current eligibility requirements are that the employee has to be there for 12 months, that they have worked 1,250 hours in the 12 months preceding the need for the leave, and that the employer has 50 employees within 75 miles of the work site. Now turn to the next slide with respect to the reasons you can use leave under the existing statute. It includes two different reasons, one of which deals with the birth or placement of a child for adoption or foster care. And then second, and more importantly for COVID, it also includes serious health conditions of an employee, a child, a parent, spouse, domestic partner, child of a domestic partner. Now, with respect to the CFRA, there's a lot of misconception that this does not apply to COVID-19. Technically speaking, COVID-19 can qualify as a serious health condition sufficient to trigger the CFRA if it results in inpatient care or continuing treatment or supervision by a healthcare provider. So do not simply rule out the CFRA as potential applicability when you're dealing with COVID-related issues. It's fact dependent and it depends on the specific reasons for the leave. Now turning to the next slide with respect to the CFRA, currently there is a guarantee of reinstatement. You must guarantee employees reinstatement to the same or comparable position upon return from the leave. Currently there's a limited key employee exception, and then there's also, and with respect to that exception, it deals with individuals who are among the highest paid 10% of the workforce. Turning to the next slide, there's also an exception for employees who employ both parents. But importantly, with respect to this state leave, typically the state and federal leave, the FMLA, can run concurrently when the reasons for taking the leave are the same and trigger application under both laws. The next area I briefly want to touch on is the new Parent Leave Act on the next slide. It's also referred to as the NPLA. Very briefly, this was a modification to the CFRA, and it was designed to revise the application with respect to leave rights for baby bonding to employers with 20 to 49 employees. Similar to the CFRA, there isn't a requirement to maintain the employee's health insurance benefits during the course of the leave. Now that we've covered the basics of the existing leave, I want to touch on how this is expanded with SB 1383 on the next slide. SB 1383 went into effect, or was signed by the governor on September 17th, 2020. It goes into effect January 1, 2021, and it significantly expands coverage under the CFRA. The first major change is it expands eligibility to small employers. It now reduces the minimum number of employees triggering coverage from 50 to 5 employees. In addition, the NPLA, which I briefly touched on, is going to be repealed at the end of this year since it's no longer applicable. And then that CFRA exemption to employers with fewer than 50 employees within 75 miles is effectively eliminated. The two components that still do remain in effect on the next slide still include 12 months of service, as well as the minimum 1,250 hours in the 12 months preceding the leave. Now, turning to the next slide, there also is some expanded definitions in terms of who a family member is and what constitutes a qualifying exigency. The expansion includes a definition to include siblings, grandparents, grandchildren, domestic partners, and all adult children, whether or not dependents of the employee, and then also children of domestic partners. Under this expanded coverage, it also permits employees to take 12 work weeks of unpaid protected leave during the 12-month period for a qualifying exigency related to covered active duty or to the call to covered active duty of an employee's spouse, domestic partner, child, or parent in the U.S. Armed Forces. Turning to the next slide, there is also a couple of things I wanted to point out that have not changed. The right to reinstatement still exists. However, the key employee exemption has been eliminated, as well as the exemption for employers who employ both parents. So now, basically, if you have both parents working for the same facility, they would technically be eligible for up to 24 weeks of unpaid protected baby bonding leave. So turning to the next slide, high-level takeaways to bring home when you're looking at your policies. If you have employers with 5 to 49 employees, in which case you wouldn't have been covered by the state law, you're going to have to develop policies to comply with this new bill. And then for employers who have 50 or more employees, you're going to need to revise your policies to address these changing eligibility requirements for purposes of coverage. And then it's very important that you train your HR professionals in terms of how to track this leave, both under the state law, the federal law, as well as some of the expanded supplemental benefits, the FFCRA, and then if you're covered, the California supplemental paid sick leave benefits. And then you're going to want to train your HR personnel to ensure compliance when you're implementing these. The next topic I briefly wanted to touch on is COVID-19 employee testing. Obviously, this is a hot area. I've noticed that there's a lot of confusion in this area. And there's really a competing interest between protecting employees and protecting employees' health and safety and protecting the health and safety of residents. And then on the other hand, there are laws that limit and prohibit discrimination associated with medical conditions and disabilities. So I briefly wanted to point out some of the highlights under employment laws, and in particular, the Americans with Disabilities Act. So turning to the next slide, the Americans with Disabilities Act, the ADA, does prohibit employers from compelling workers to submit to medical examinations that are not job-related and consistent with business necessity. The ADA does state and requires that any mandatory medical tests has to be both job-related and consistent with business necessity. So in most cases, applying the standard, an employer may take screening steps because an individual with the virus will pose a direct threat to the health of others. And the testing administered by employers has to be consistent with current CDC guidance. If so, the EEOC has stated that this will generally satisfy the ADA's business necessity standard. So turning to the next slide, and something I wanted to highlight is the EEOC's ban on the employer antibody tests. There was some guidance. Again, this is guidance, not necessarily binding law, that was issued by the EEOC in July. The guidance banned employers from testing employees for COVID-19 antibodies as a condition of returning them to work. As part of this guidance, the EEOC relies on the CDC's recommendation and states that the antibody tests do not meet the ADA's job-related and consistent with business necessity standard. I want to point this out. While the EEOC guidance may be outdated, since we have received additional CDC guidance since this EEOC guidance came out, I did want to flag this for you and your particular health facility, and whether you do conduct employee antibody tests is going to be fact dependent, but you should be aware of this guidance, as the EEOC has specifically said that employers in general, not specific to health facilities, should not use these tests if they're using them as a condition of returning employees to work. Now, turning to the next slide with respect to high-level considerations on employee testing. This is highly dependent on the specific health facility that you work at, whether you're a skilled nursing facility, an ICF, or some other health facility. Obviously, there's different recommendations and in some cases laws that address skilled nursing facilities on one hand and other health facilities on the other. So you need to keep in mind that you comply with all federal, state, and local laws in this area, and be mindful of what are simply recommendations and guidance, such as that we see from the CDC or the CDPH, as compared to what are laws and regulations. And in all cases, keep in mind that there are these considerations under the ADA and also the state law that prohibit certain kinds of tests in the employment discrimination sphere. In all cases, when you're considering what testing to roll out, whether it's part of your mitigation plan that was required under the CDPH for skilled nursing facilities, or it relates to other health facilities, you want to keep in mind to implement the least invasive method possible. You should attempt to apply the testing and screening policies consistently to avoid a discrimination or retaliation charge. And you certainly want to give employees notice of what that program entails. And in most cases, you should consider requiring employees to acknowledge and receive a waiver of their specific privacy rights as part of that program. You also do want to consider some of the wage and hour implications for the testing. And that's just a natural segue to get into the next area, which is time spent on COVID-19 safety protocols. So I get a lot of questions in this area with respect to what is compensable, and I wanted to flag temperature checks and then also sanitation procedures and PPE. So first, with respect to temperature checks, in general in California, the California law is that you must pay for all time where an employee is under the employer's control. Mandatory temperature checks are likely going to be compensable for purposes of California law. The same would likely apply to mandatory tests, COVID tests. However, or another thing to point out is also time spent waiting in line to undergo these various tests are also likely to be compensable, even if it's just for a short period of time. On the other hand, if you're requiring employees to take temperatures at home, they are probably not going to be deemed compensable if it's just a simple temperature and wellness check. But there are specific facts that might change this depending on the burden that's associated with the employee and what you're mandating. One thing also with respect to testing and temperature checks is if you are sending employees home, you also want to be mindful of any reporting time obligations. There are certain reporting time obligations under the wage orders and under state law. If an employee is scheduled to work and doesn't work that scheduled time period, So please keep in reporting time obligations when you're dealing with employees sending employees home. Another area I briefly want to touch on is sanitation procedures and PPE and time spent on those protocols on the next slide. Employees must be paid for all time cleaning and sanitizing the workplace or equipment, as well as time spent changing into safety gear or PPE is likely going to be compensable if it's integral part of the primary job duties of the employee, mainly with respect to healthcare personnel and potentially non-healthcare personnel. So with respect to this issue and compensating employees, it's important that you review your timekeeping policies and provide very clear guidance to employees to ensure that they are clocked in while they're performing these duties. And if they're not specifically clocked in, that there is a mechanism for how you're tracking and recording this time so that all time under the employer's control and all time worked is actually being paid. Okay, so let's move on to COVID-19 exposure notice and reporting requirements. There's been a number of developments in this area. The main development is AB 685, which was signed by the governor in September of this year. The law goes into effect on January 1st, and it requires an exhaustive notice and reporting requirement in the event that there is a COVID-19 exposure in the workplace, and it dramatically expands Cal OSHA's authority to issue stop work orders to workplaces that pose a risk of imminent hazard relating to COVID-19. So let me explain what a triggering event is for purposes of the notice. It applies to a potential exposure based on a positive confirmed case of COVID-19 in the workplace. An employer is considered to have notice of this when a public health official, licensed medical provider, an employee or their emergency contact, the employer's testing protocol, or a subcontracted employer actually reports that the employee is or was exposed to a qualifying individual. So let me explain what a qualifying individual is on the next slide. This includes individual who has a laboratory confirmed case of COVID-19, are diagnosed with COVID-19 by a licensed healthcare provider, are under a COVID-19 related order to isolate provided by a public health official, or have died due to COVID-19 as determined by the county public health department. If a qualified individual is identified and the employer has notice of a potential exposure, then the employer must provide notice to the workforce and in fact has to take action within one business day of the potential exposure. So some tight deadlines to comply with this law. Turn to the next slide. The notice requirements, you need to include written notice to all employees and employers of the subcontracted employees who were at the work site within the infectious period who may have been exposed to COVID-19. You should also consider notifying third parties who are at the work site during the infectious period. And you need to provide notice to employee representatives, which would include unions, and in some occasions, the attorneys who represent employees. Turning to the next slide, the content of the written notice should include the various COVID-19 related benefits that the employee might be eligible for, as well as the company's disinfection protocols and safety plan to eliminate any further exposures per CDC guidelines. In terms of the form of the notice, there's a variety of ways you can notify employees as long as it's reasonably anticipated to be received by the employee within one business day. And the notice has to be in English and in the language understood by a majority of the employees. Now, turning to the next slide, there's some important record-keeping requirements, one of which includes that employers must maintain records of the written notification of COVID-19 potential exposures or outbreaks for at least 3 years, that information must remain and be kept confidential, similar to information you receive with respect to employees' private medical information. The other main components of this bill, which we're addressing on the next slide, deals with Cal OSHA's expanded authority. Under this expanded authority, they now have the ability to act when an employee believes employees are exposed to COVID-19 in a manner as to constitute an imminent hazard. The key ways that this changes with this new law is that the 15-day notice period for employees to provide evidence in support of their defenses in response to Cal OSHA's serious citations has been removed. So there's an immediate obligation to produce information and documents. Very briefly on the next slide, a couple of key takeaways on this bill. It's essential that you have an action plan in place in terms of how to identify workplace risks under your mitigation plan, how to control exposure, and then how to address and respond to COVID-19 exposure in the workplace. It's going to be pretty important that you have appropriate training in place so that when this law goes into effect, to the extent that there is a triggering event, you can send out these notices within the 1-day period. Given the potential for a serious citation, this is certainly something you want to consult with your labor counsel when you're developing your action plan. And whenever there is, in fact, a positive confirmed case or where Cal OSHA contacts you, that's another situation where you probably want to get your labor counsel on the phone. Okay, so turning to the next area, I briefly wanted to touch on COVID-19 PAGA-based lawsuits. We are starting to see a large increase in COVID-19 PAGA lawsuits. PAGA lawsuits deal with representative actions where an aggrieved employee can essentially step into the state's shoe and bring a representative action to recover civil penalties on behalf of a representative group for any alleged violation of the labor code. That's where we've typically seen a lot of this PAGA litigation surrounding violations of the labor code. This typically comes up in wage and hour claims, but these PAGA claims and remedies are also available to employees for alleged Cal OSHA violations. So this is something to keep in mind. Typically in the past, this was relatively rare, but as we've seen plaintiffs' attorneys shifting to the focus on health and safety, we're seeing an increase in this, and we're expecting to see an increase with skilled nursing facilities and ICFs in this area. So very briefly, the types of ways I could see this coming about with respect to PAGA-related claims could come up in a variety of different situations, including the failure to provide a safe and healthful workplace, the failure to furnish and use safety devices or safeguards, the failure to adopt and use practices, processes, and operations that are adequate to make workplace safe and healthful, the failure to implement and maintain effective written injury prevention programs, requiring or permitting an employee to go into or be in the workplace that is not safe and healthful. Also, the failure to do every other thing reasonably necessary to protect the life, safety, and health of other employees. Those are just a few of the ones I wanted to flag for you. Also, I wanted to let you know that there is a somewhat unique procedure for how these claims are probably going to be pursued based on OSHA-related events. In most cases, I think plaintiffs will need to provide the LWA as well as the Division of Occupational Health and Safety with notice of these potential allegations. The Occupational Health and Safety Division has essentially 3 days to inspect and investigate complaints of serious violations, and then 14 days for non-serious violations. Once the agency inspects, it has 16 months in most cases to issue a citation. So I think we're going to see plaintiffs file these PAGA-related claims in 2 different situations. One, if the agency does not inspect or investigate within the applicable period of time, or they do investigate, but they don't actually issue a citation. Those are the ways I see it coming up. And turn to the next slide with respect to a couple of key takeaways when you're considering how risk management associated with PAGA-related lawsuits. It's vitally important that you stay abreast to federal, state, and local orders guidance and ensure that you're meeting the best practices with respect to workplace safety. Again, the guidance and recommendations, even though they're not binding law, are going to be a good way to defend a potential claim in this particular area. Keep in mind that if you receive notice of a OSHA-based PAGA lawsuit, you should also expect possible OSHA inspection and investigation. And in light of that, you should quickly prepare and respond. Again, this is an area you'd probably want to consult your labor counsel with. And keep in mind that you can prevent these types of OSHA-based PAGA lawsuits by addressing and remedying the alleged dangerous condition directly with OSHA. Again, this is another thing you want to probably consult with labor counsel on. Okay, so the next main area I wanted to touch on is the expanded workers' compensation law changes. As you may or may not know, there was an executive order issued by the governor that was issued on May 6th of 2020. This created a presumption that employees who test positive for COVID-19 have contracted the virus in the course of employment for the purposes of workers' compensation benefits. If the employee tested positive for or was diagnosed with COVID-19 within 14 days after the employee performed work at their place of employment and at the employer's direction, as well as that they performed the work on or after March 19th, 2020. Under the executive order, you still could rebut the presumption if you presented other evidence. It did apply for COVID-related illnesses between March 19th and July 5th. Now, there's been some dramatic changes that apply to this presumption moving forward after the July 5th date, and that is with respect to SB 1159 that went into effect in September of 2020. It essentially codifies the executive order and also creates an important presumption that applies to first responders and certain healthcare workers who suffer a COVID-related illness or injury, as well as in some situations for all employers if there's an actual outbreak. So very briefly, in terms of where this presumption will apply, it doesn't apply to all health facilities. The language in the statute and addressed in the slide calls out a number of different situations where the presumption will apply. One, it could apply to employees who provide direct patient care or custodial employees in contact with COVID-19 patients who work at very specific health facilities identified in certain sections of the Health and Safety Code. Keep in mind that this would apply to skilled nursing facilities. However, it would not apply to a nursing facility that's certified to participate in a Medicare or Medicaid program. Keep in mind, it also doesn't apply to most ICFs, except for intermediate care facility developmentally disabled continuous nursing facilities. Those are the specific health facilities that you want to keep in mind. There's also language where the presumption could kick in for other employees of these same health facilities, other than those that were described above, unless the employer can establish that the employee had no contact with a COVID-19 positive patient in the previous 14 days. So that's the way it can come up with respect to the healthcare presumption. It can also come up if there's an actual outbreak. The outbreak depends on the size of your facility. but an outbreak would include employees who test positive during an outbreak at their specific place of employment, not at the employee's home or residence, and work for an employer with 5 or more employees. With respect to the outbreak itself, it would include 4 employees or 4% of the employee population testing positive for COVID-19, again, depending on the size of the workforce at the specific workplace and whether you're over or under 100 employees. Key takeaways in light of this workers' compensation expansion, you obviously want to revise your policies to address screening for COVID-19 related symptoms for employees who are reporting to work. It's vitally important that you also modify your policies and require training so that employees are immediately reporting these illnesses, since the time period for attempting to rebut this presumption is very limited. And then you want to develop procedures for managing and responding to COVID-19 cases as they occur. One last thing I wanted to touch on, since we've covered a lot of different areas with respect to labor and employment laws, is updating your employment handbooks and policies. If you're hit with a lawsuit related to COVID-19 as it relates to your employees, one of the first offenses is a compliant policy. So you should carefully review your employment policies to determine that they comply with these newly revised laws, as well as some of the newly revised guidance and recommendation. A couple key areas to focus on would be policies surrounding COVID-19 mitigation efforts, whether that's screening, testing, notice and reporting, PPE, staffing shortages, designation of space, employee communications. You also want to be mindful of anti-discrimination and anti-retaliation provisions, since we now have a lot of new laws where employees are subject to these anti-retaliation provisions in those statutes. You clearly want to modify your leaves of absence policies, your time and attendance policies, and if you've changed the way you're implementing meal and rest breaks in light of COVID-19, you want to modify those policies as well. And then keep in mind, reporting time and travel policies are another area that might be of concern. So with that, that's 50 minutes on the recent labor and employment developments that have occurred over the last 3 or 4 months. Thank you for joining me. Appreciate it.